Scottish Labour leader Anna Sarr was calling for a change of leadership at NHS Greater Glasgow and Clyde after it was named as a suspect in a corporate homicide investigation. In 2021, police began a criminal probe into the deaths of 4 people at Glasgow's Queen Elizabeth University Hospital campus. One of them was 10-year-old Millie Main. Her mum, Kimberly Darragh, previously said her daughter's death was murder. Well, I spoke to the former president of the Scottish Bar Association, Tommy Ross KC, who tells me what corporate homicide actually means.
The essential features of it is that the organisation has owed a duty of care to a victim, that there has been a gross breach by the organisation of the duty of care, and that gross breach has led to a death, and it involves consideration of the way in which senior management organised his activities, and as I say, there was required to be proof there had been a substantial element of gross breach involved in the way in which they organised their affairs.
What is the kind of burden of proof?
It seems to me that it's an incredibly high burden of proof, because there has to be a gross breach of the duty, which involves conduct which falls far below what could reasonably have been expected. That's the first thing, but in addition, there requires to be analysis of the way in which senior management has conducted its activities, and would have to be satisfied that there was a serious breach which had caused the victim's death, in the sense of being a material factor in the death of the victim.
I was on various websites this morning, including legal websites and some big Scottish and UK firms. I couldn't find any cases that have been Scottish, other than the suggestion that maybe one of the prison cases might become corporate homicide. What has there been in time about this?
I'm unaware of any cases. The Act received royal assent about 16 years ago. I don't know of any prosecutions under the Act in Scotland. It's very close in its scope to the Health and Safety at Work Act, and so the tendency has been that where there are serious accidents which have led to serious injury or death, Crown Office has usually elected to proceed under the Health and Safety at Work Act, which from my own limited experience is much, much easier to prove than a corporate homicide would be to prove.
Because as I understand it, some of this was about serious accidents at work, and the liability of a corporation for, let's say, somebody falling into a vat of concrete or something, and then that could be corporate homicide, because you can have a look at the behaviour of all the managers and the supervisors, and were they adequate? Yeah,
I mean, that's exactly right, but the point is that the Crown really, in a situation like that, in theory, it could be a health and safety prosecution, or it could be a corporate homicide prosecution in some cases. But it's easy to understand why the Crown would opt to prosecute the charge which is easier to prove rather than the one which is more difficult. So there would be nothing unusual about any organisation being prosecuted under the Health and Safety at Work Act 1974. But this is new, which suggests that the Crown have taken at least a preliminary view which is different from the one that they usually take in these cases.
This is a health board. Would anybody go to jail for this?
No, as I read the legislation, the penalty is an unlimited fine, which could be measured in tens or hundreds of thousands. But interestingly, the court also has the power to make what is called a remedial order. And that would be a situation where the prosecution identify the steps which are necessary to remedy the breach of duty, and the organisation is then essentially ordered by the court to take those steps, and I presume there's some form of review to make sure that's done.
Okay, so there's a remedial process, so you could be ordered to change the way you work. But if it's a fine, if it's a big public body and it's a fine, we pay that. That's the taxpayer pays it.
Yeah, well, that's exactly right, and that's always a factor in cases involving any public body. You know, when a health and safety breach is identified and prosecuted, inevitably the consequence often is the financial penalty imposed is ultimately paid by the taxpayer, and we're in the same situation here.
How significant is it, do you think, as somebody in the business, if you like, that this is a health board?
I think it is significant, because you would imagine if health boards are dealing with people who have health difficulties, then every single patient presents the possibility that some form of prosecution could result. So anytime there's an adverse outcome in relation to the patient, that will be looked at. And I suppose it must be extremely concerning for health boards if there are adverse consequences which are out with their control, that nevertheless it might lead to calls for them being prosecuted. And I suppose ultimately it might lead to people seeking work out with the health board if they think they will have a senior position in NHS Scotland and I'm going to be liable for prosecution. Maybe I would prefer to go and work for a bank.
Tommy Ross Casey having a quick look into the future. It's Drive Time on BBC Radio Scotland with John Beattie. The time is just after 5:31.